I'm Emma Heim.
Hi, my name is Owen Bates, and we are from Westfield Academy and Central School, and our teacher is Mr. Berner.
Hey, I just want to say before I check out, thank you guys for giving us your time on a Sunday and providing this awesome educational experience. Thank you so much.
Thank you. So we, as you know, are doing question number 2. Quote, a Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. End of quote. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
Thank you. The Bill of Rights is an irreplaceable part of the American Constitution. The original purpose of these amendments were to appease the anti-federalist fear of the government infringing upon natural rights. As stated by William J. Brennan Jr., the framers of the Bill of Rights did not purport to create rights, rather they designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing.
Throughout the evolution of America, the Bill of Rights has protected America's ability to speak out against and defend themselves from the overreaching power of the federal government. We agree with Thomas Jefferson. All people are entitled to a Bill of Rights.
Before the 14th Amendment and the doctrine of incorporation, the National Bill of Rights was not applicable to the states. This presented a great disadvantage in cases such as Barron v. Baltimore and Adamson v. California. Individual rights were not protected, and the powers granted to the states abounded. However, with the ratification of the 14th Amendment in 1868 and the creation of the doctrine of incorporation, the federal as well as the state governments needed to uphold the first 10 amendments.
State legislation must adhere to not only their own Bill of Rights, but the National Bill of Rights as well. This is a bigger challenge for the states, as their Bill of Rights often contain more specific rights, such as those in the New York State Constitution, like workers' compensation and damages for deathly injuries.
Another advantage to a national Bill of Rights presents itself in the necessity to pass legislation that is in line with these liberties. If the legislation fails to meet these standards, the judicial branch has the power to reevaluate the constitutionality of these laws, as stated in Marbury v. Madison. As a result of this process, the power possessed by the legislative branch is checked in order to uphold the citizens' natural rights.
The 10th Amendment also checks the federal government's power in that it gives the states the flexibility to decide what other liberties are essential to their inhabitants. This presents itself as an advantage because it requires the state and federal government to work together in order to secure the natural rights of the American people. With the existence of two forms of Bill of Rights, the people are further protected from an obstruction of their liberties.
Positive and negative rights are both evident in the National and State Bill of Rights. While negative rights restrict government action, positive rights instruct the government on how to uphold rights. Freedom of speech and religion, as protected in the First Amendment, are examples of negative rights, while examples of positive rights include the Sixth and Eighth Amendment.
When creating a Bill of Rights and additional amendments, the government must understand the balance of these two relationships. Although positive rights are essential for the government to be able to provide specific services and safety to its citizens, they do not fully protect the citizens from the overreach in government. Whereas negative rights restrict the government from unjust action, however, it does not allow the government to provide services to its citizens.
In the end, when both of these rights are created together, the goal to protect the freedom of its citizens is achieved. Therefore, neither right is more important than the other, and both are quintessential in protecting the liberties of its citizens.
John Locke states that the purpose of our government is to protect rights and its citizens. The Bill of Rights specifically outlines these liberties. As Henry H. Jackson said, the very purpose of a Bill of Rights is to withdraw certain objects from vicissitudes of political controversy. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly may not be submitted to vote. They depend on no elections. We the people believe that every nation is entitled to this essential protection of their liberties.
Well, thank you very much. So there are a number of individual rights that the Supreme Court has recognized and upheld over the years. that are not expressly based in the Constitution, in the text of the Constitution. So one example would be the Oberfeld decision, where the court recognized the right to marriage among people of the same sex. When is it appropriate for the court to identify rights not found directly in the text of the Constitution, and what standards should the court use to do that?
So we see that the Ninth Amendment gives all other rights not mentioned in the Constitution or the Bill of Rights to the people. And privacy has been a big issue recently, especially during the era of electronics, social media, iPhones. One case that demonstrates the right to privacy is Griswold v. Connecticut. When the contraception issue was brought up, do people have the right to use contraception, and is that a private right? Is that something the government should interfere upon? And it was established that you have that right to privacy. Privacy is something that is given to the people under the Ninth Amendment. A suggestion would be maybe we should add an amendment specifically stating the right to privacy. Maybe just to get that in there, I believe it would be very beneficial, because yes, we have the Ninth Amendment, which incorporates privacy. However, with this infringement, with things like the Patriot Act, when the presidents can look into our phones and social medias because of a threat of terrorism that may not even be valid, this is a protection that we need to have. It's something that we should consider adding to the Constitution to further instruct the courts on how to decide things like this.
So you all did a great job of listing what are the rights that are listed in the Bill of Rights, and how important they are to the foundation of our democracy. But are there times that the government can limit those rights? And if there are proposed legislation or whatnot that limits those rights, if that's appropriate, what should be the court's reasoning in analyzing what limits are appropriate versus what limits might not be appropriate?
So in the court case, Cox v. New Hampshire, it has an example of the limits on freedom of speech, where it states that the government cannot regulate the contents within speech, but they can regulate the time, place, and manner restrictions on the speech that is provided.
Another one is the Brandenburg test, where if the speech incites a type of violence, then that can be regulated. And I think to that second question that when you look at it, it's basically, it comes down to the common good versus individual rights. The common good, it really helps the society as a whole, while the individual rights helps the individual specifically. So when you look at it, if the limit if the right itself, say for example the Brandenburg test, where if that speech incites a type of violence and it hurts the community together, then that's when you can limit it. But if it just is limiting because it's trying to take power away from the individual, then that isn't right.
Another place where we see the court limiting things in the First Amendment, like free speech, is in school districts, in a place where school, and this is very relevant to me and my colleagues as we are still in high school. And we see this in court cases such as Bethel School District v. Fraser, when some sexual references were made in the school speech, and it was declared that that was not the time, place, or manner in which he should have delivered this speech. And it was upheld that, well, as they said in Tinker v. Des Moines, while students do not lose all rights when they walk into a school building, they are limited, and rights are limited because the constitutions of every state ensure education for all children. And if your speech infringes upon that, then it will be limited, and because you are infringing on someone else's right.
The Supreme Court also has limited stuff on religion in the First Amendment, and examples of the court case Employment Division v. Smith, where a Native American group was using the drug peyote, and the counselors of the groups were discovering the drug was like a hallucinogenic drug, and it was creating problems through the Native American groups, and that drug was illegal to use. And that in the end, the ruling of the court case stated that the Native Americans were not allowed to use this drug based on the laws that were created.
Let me throw a question at you, since you've mentioned several cases just now. The Supreme Court has the role of review. and in recognizing the Bill of Rights and it's what's contained therein? Has the Supreme Court always gotten it right? And if they didn't, were they able to correct it each time?
So, a court case that we see that we don't agree with and we think that the Supreme Court got wrong is Schenck v. US. When Schenck was charged under the Espionage Act and his freedom of speech was limited because of his protesting the draft, it was found that it inhibited a wartime action. However, we think that the court got this wrong. And while this court case has never been outright reviewed and reestablished and taken aback, we see court cases such as Snyder v. Phelps, when the Westboro Baptist Church was protesting outside of a military funeral, and the court upheld that it was their right to do this. It was their right to expression, to protest. We see that although the court has never gone back and specifically reevaluated Schenck, that this was a time they got it wrong. However, we're working towards making that up. We're working towards getting our free speech back as an essential protection in the Bill of Rights.
We also, my colleagues and I both agree that Wisconsin v. Yoder is also a very case that we don't agree with, because instead of looking at the religious freedoms, the equal opportunity of children is violated, because kids aren't getting the same education because they're being taken out of school at 8th grade.
So often there is a very low bar for the court to take away your individual right. So for example, if I park my car in front of a fire hydrant, the government may tow my car, take my car away, and now I have to pay $300 to get it back. And that happens every single day. How is that appropriate? How can the government so easily take away people's property or their rights?
So this is a very difficult balance, especially in today's society. How are we going to balance individual rights with the common good? And another example of this would be the COVID-19 pandemic and mask wearing. A lot of states have gotten rid of masks, such as Texas or Mississippi, but it's something that's really debated about. Does the government have the right to make us wear masks? And in their opposition, there's people in opposition of this are saying, it's my right to freedom of expression not to wear a mask, to express myself. And we have to find that perfect balance. And I don't think there will be a perfect balance. And I don't know if we can ever find a perfect balance. However, we need to instruct the government. This is why we have negative rights. This is why we have the right to freedom of speech, the right to alter or abolish our government. If we feel that they are truly infringing upon our rights, we have the right to amend the Constitution. We have the right to speak out. We have the right to declare our rights and establish them.
And that is time. Congratulations, New York. Well done. I'm going to turn it over to the judges so they can provide you feedback.
What a great presentation, and just overloaded with precedent and case law. You had a case for everything you cited, which was absolutely fantastic. The Cox versus New Hampshire, Brandenburg, Bethel, Smith, Schenck, Schneider, Yoder. Just on and on and on. Absolutely terrific case law to back up your arguments. Wonderful opening presentation going back to Marbury versus Madison, John Locke, Henry Jackson. A really comprehensive, well-reasoned, very lawyerly, precise. It was almost as if you were arguing in front of the United States Supreme Court, giving them precedent after precedent after precedent. It's clear that you've put in enormous amounts of work, and not only read these cases, but understand how to apply them and where they do apply and where they don't. Fantastic job, New York.
Thank you.
Thank you.
I agree. You guys did a really, really great job. Everyone answered, everyone participated, and you obviously had a lot of evidence. Two things I wanted to point out that I thought were really great. One is that you said, neither right is more important. I don't know if anyone had given that kind of perspective yet, which is, they're both positive and negative rights are important. Neither is one more. So I thought that was really, really good. And I like that you, when the question was asked about what which ones might be wrong, what court cases might be wrong. You mentioned Wisconsin versus Yoder. And again, that was something new that we hadn't heard. And it was, I like that. I like that boldness to say, no, here are some times when the courts get it wrong. So good job all around, and congratulations to your teacher.
Thank you.
Thank you.
Lovely. I agree with my colleagues. Wonderful examples, good case authority that was cited, good positional statements indicating and articulating your own personal position in respect to certain issues, and a very lovely opening commentary with some good examples as well. Good luck to you all.
Thank you.
Thank you.
Thank you.
Thank you so much for your time again on a Sunday. Really, really do appreciate it.
Our privilege to learn from